Good afternoon everyone. Sorry I'm a bit red-faced. I've been out doing chainsawing most of the day, getting rid of debris on top of carports. I thought I'd give you a little treat. We've been waiting for the reserve decision from Justice of the Peace J. Jonson NT Holding. These were the people that presided over the hearing on the 27th of January for the speed ticket. Now I've put in a request for the complete transcript because this is just the judge's version. This is what they've written down as they go. This is not the full and final complete transcript. This is only their notes put in the text with their judgment. Of course I'm going to be appealing it because as far as they're concerned, old Constable David Lee, or Senior Constable David Lee, the pride of Waitakere Road Policing Unit, apparently just him seeing it is enough evidence to prove beyond a reasonable doubt, because all of the evidence that was supplied showed nothing but an 80k area. But apparently his testimony enough is what's considered, which doesn't quite seem fair. He also points out certain things, like for instance he said that the stationary mode in the speed detectors manual, page 13, when I was saying you're not to operate the detector. Now they're not telling me, the target vehicle, not to operate the detector, are they? Because I don't have one. Well, if I was a general person I wouldn't. I do, but never mind. The operator's manual is for, let's see if you can figure it out. It's in the title, David. Speed detector equipment operator. Okay, operator's manual, David. Okay, so that means that the manual applies to the operator, not to the general fucking public. But anyway, he says in page 13 that the moving mode, which is the point I pointed out about the 250 metres within a reducive speed zone, where he's not supposed to be operating his gadget, he apparently that applies to the target vehicles, which it doesn't. And if David had actually taken the time to turn one page over, you'd see on page 14 that it states moving mode, all principles of stationary mode apply in moving mode. And if that doesn't work for him, he can go to page 47 where it clearly states it again. So nothing about it applying to the target vehicle, which is what they wanted to make it out to. But without further ado, I'm going to read you this piece of crap so you guys can all see what I'm going to be appealing. 1. Mr. Keane was issued an infringement offence notice by the New Zealand Police for being the driver, for being allegedly the driver who drove a vehicle on the road exceeding 60 kilometres per hour, being the applicable speed limit. No, it wasn't. At his first appearance on the 19th of September, which was done in paper, I never appeared anywhere on the 19th of September, I filed a notice of appearance, Mr. Keane entered a not guilty plea. Yes, because you can do that via paper. I didn't show up, I didn't take note of that you must attend, or a warrant for arrest will be issued. I didn't take notice of that at all. They can go fuck themselves. Entered a not guilty plea to the offence, and a judge-alone trial was set down at Waitakere Court on the 27th of January 2023. At that first appearance, he provided the court with a submission labelled. No, that wasn't my first appearance. See, Justice of the Peace can't even get that right. The first appearance is where you get to enter your plea. That was the 19th of September. That was not my first appearance. I mean, that was my first appearance. The 27th of January was not my first appearance. It was the defended hearing. So Justice of the Peace can't even get their simple facts straight. Moving on. He provided the court with submissions labelled Memorandum of Appearance. No, it was called Notice of Appearance. This included a request for full disclosure of a number of documents. Documents such as any criminal or traffic history of any witness they tend to call, because it goes to the validity of that witness. But no, they don't want to tell you that any of the police's criminal or traffic history, even though they're very happy to supply you yours. The court advised the prosecution that They were to disclose all of the documents relevant to the charge, Mr. Keane. Mr. Keane also sought assurances that the matter would be heard with adherence to the New Zealand Bill of Rights Act Section 25C, which is fair and impartial. So that in relation to determine of the charge, he would be presumed innocent until proven guilty according to law. No, it's until proven guilty beyond a reasonable doubt. Again, simple facts, Justice of the Peace can't get it right. Prior to the commencement of the judge alone trial on the 27th of January, judge alone trial, I didn't see any judge. Did you see any judge? I didn't see any judge. There was no judge there. Judge alone trial, a written submission on 2 matters was received by the court from Mr. Keane. It was read in chambers by both justices before, no, they're not justices, by both justices of the peace. Don't go confusing yourself with justices such as High Court justices. You're not. Mr. Keane's appearance and a determination made in court. For matter 1, Mr. Keane requested a court-appointed lawyer to assist with his case. No, I didn't. Got that wrong. I requested that the court assign a lawyer who's a member of the bar to assist me in cross-examination. I didn't want any lawyer's help with my case, but as far as I was concerned, and according to law, I'm precluded from being able to cross-examine anyone because I'm not a member of the bar. But anyway, it was explained that the court does not assign lawyers. Really? Tell that to Justice Mathers. She assigned one back in 2017. Justice Mathers assigned Roger Chambers, a QC, to assist the court. Oh, and apparently me, but that's a side issue.
So I will give you just a couple of minutes to talk to Mr. Chambers, and I know he's not your lawyer. He's here to assist me, but by talking to you and explaining perhaps in a little bit more detail, because I can't advise you.
Of course.
You might be able to sort this out.
Okay, so it's just a decision as to whether or not to proceed today, or come back once I can provide that evidence.
Yes, and what I would suggest is that if you are not successful in having the charge dismissed on the next occasion, if that's what you choose to do, that you are given the full disclosure and that you'd be ready. You'd be in a position to proceed by way of a defendant hearing the next time.
Sure.
Okay.
Thank you.
Mr. Chambers, are you happy with that?
Yes, I'm happy with that.
Sergeant, you might not necessarily be happy with it, but that's what I have to do, okay? So, how long do you want? 10 minutes, perhaps?
Oh, just a couple of minutes. 2 or 3 minutes.
Yes, Mr. Keane. Mr. Chambers.
Yes, I have discussed matters with Mr. Keane. He will take the opportunity of a brief adjournment to enable Your Honour to receive the paperwork. His only additional request is that if this matter could be reconsidered, preferably by Your Honour, as soon as reasonably possible.
Well, I am seized of it, sir.
Yes.
That's going to take a little bit of time to sort out another date.
Yes.
In the meantime, what I'm going to do, as I said, is ask the prosecution to provide you,
Full case file would be fantastic.
well, the information that you have.
Perhaps just a disclosure order, ma'am, might be the easiest way to order it.
So full disclosure in terms of.
Well, a full disclosure includes everything relevant to the case in essence. That was everything we've got. He's got 2.
So they do assign, so don't lie. It was explained that the court does not assign lawyers as legal and legal aid is not available for infringement matters. Well, I wonder why. It's probably because it's such a good cash cow for you, and you spend near on $500 million in legal aid for lawyers that do fuck all for their clients. So yeah, I can see why you wouldn't want to waste more money. You'd rather it come in from people not knowing how to defend themselves for being innocent. Everything runs on presumption, doesn't it? Where were we? Mr. Keane was offered an adjournment to enable him to engage his own legal representation. Yeah, I didn't ask for I said I'd ask for an adjournment if the court chose to go ahead with the trial to get the assigned counsel to assist me in cross-examination. I wasn't asking for an adjournment at all otherwise. As he was not a lawyer himself, he was concerned his examination of a witness would not be given the same weight as the prosecution during the trial. It was explained that the court is very familiar with self-representation by defendants, and Mr. Keane would be provided with a fair hearing with equal weight and consideration given to evidence and questioning provided by all parties. Well, is that right? Because I said I was in the 80k area. Did that get given the same weight as Constable fucking David Lee saying that I was in a 60k area? No, it wasn't. Because he was a cop, you gave him more weight on his side, because I provided just as much evidence as New Zealand Police did, as far as photos were concerned. I provided the same photos as what they did. So, I guess the Justices of the Peace were lying then. Perhaps Selwyn Hayworth, oh, no, he's a useless piece of shit. Perhaps the president of Auckland JP Association, Selwyn Hayworth, could fill them in. Because we're going to be appealing, and you know what? Then I will be in front of judge. No more of this Justice of the Peace crap. And if you guys want to go ahead and mislead the court and misrepresent things under the Fair Trading Act, 1986, Section 13 and 9, you want to look at that. Because I went in there expecting fair trading. The court did not trade fairly. And as far as res judicatum is concerned, I don't agree with or consent to any judgment they've made, so let's go to a higher court. Right, where were we? 5. Matter 2. Mr. Keane sought a discharge under Section 147 of the Criminal Procedure Act 2011 because of an abusive process by the police in not providing evidence he had requested. It was determined that all the disclosure documents requested relating to the offence being charged had been provided by the police to Mr. Keane. No, they weren't. The prosecution supplied a PCL 2750622 with particulars of witness. Okay, guys, that's the form. That's called a particular of witnesses. If you're challenging a speeding ticket or a stationary offence or a moving vehicle offence, a bus lane ticket, anything, and they supply you statements from different people, those statements mean fuck all. Unless they have a particulars of witness, you have not been supplied a witness list. For example, Tony's case with the Auckland Airport, we've been supplied 6 different statements, and yet the police prosecutor on the 9th of November stated he didn't even know how many witnesses there were. That was 4 months after the alleged offence. They still hadn't figured out whether there was going to be 3 or 4 witnesses. So if there's 3 or 4, why have we been given 6 statements? It's all to put you off challenging things. They can provide 400 fucking statements as far as I'm concerned. None of it means shit, and a lot of it they are misleading the court and misrepresenting facts. Constable here, perhaps you should look at that, Cherie, before you lie in your sworn statement that's going to be used in evidential proceedings. Perhaps you should think about that a little bit more, Cherie and Aaron, because you lied your asses off. The video camera footage, and thank you so much for Auckland Airport for your camera footage of it. I've got that all queued up, ready to release to the general public. It's just shocking, mate. Anyway, particulars of witness and request for summons under Section 159 of the CPA. The Section 147 dismissal was declined. Mr. Keane indicated he was satisfied with the court's responses and for the judge-alone trial to proceed. Yeah, because I get to say that. 6. The charge was laid under the Land Transport Act 1998, Section 40 and Road User Rules 2004, 5.1. Subsection 1, alleging Mr. Keane on the 15th of April 2022 at Waimaku drove a vehicle on a road at a speed exceeding 60 kilometres per hour, the applicable speed limit. No, it fucking wasn't. I was in an 80k area. In this matter, it was for the prosecution to prove beyond a reasonable doubt the elements of the offence, namely the date, the time and the place of the offence occurred, that Mr. Keane was the driver. Okay, so all of you people saying they just go after the registered user, no, they have to satisfy every element of the crime: time, date, place, that the equipment was working properly, and that the alleged defendant is the person that was the driver. Okay, that's what they must satisfy of the vehicle in question. That the speed limit at that place the alleged speed was recorded was 60 kilometres per hour. They never supplied any evidence of that whatsoever. And that the posted speed was exceeded. Prosecution examination in chief. This is where old prosecutor Mr. Mackenzie, I fucking like to swing my dick around the courtroom and control everybody in it, even though you're just a fucking prosecutor. You should stop yelling at people in courthouses and telling them what they should be doing. It's not your fucking job, Sergeant Mackenzie. Do you not understand that, you fucking half-wit? You want to yell at other self-reps that go in and try and hand things to the registrar? Tell them that they shouldn't do that they should give it to the duty solicitor, even though they don't even know who the fuck the duty solicitor is, because there's no muppet standing around with a giant sign on his chest saying, duty solicitor? And don't think I'm angry. I'm just being passionate. There's no anger here, because I think it's all a fucking crack up. Anyway, prosecution in chief. 7. Senior Constable David Lee from Henderson Road Policing Unit appeared as the witness for the prosecution. Really? Was he the witness or was he the officer in charge? Because he had a few different hats on. You referred to him as the officer in charge while he was in the witness stand. So which was he? I mean, I don't want to witness tamper, and yet you fucking cunts at the police say if you've got any questions, contact the OIC, officer in charge. But then you go and contact them, ask them some questions, and you might get done for witness tampering because that's the sole witness. So how does that work, police? Could it be that you have a greater fucking level of professionalism and a greater weight given to police testimony? Could that be it? Could it be that you don't know what the fuck you're doing? Because David on the stand sounded like a fucking half-wit. He really did. You guys can listen to it. It's up there for all to listen to. The court denied a request for him to read his written statement. Yeah, the only thing you're allowed to refer to, David, on the stand is called your notes made at the time. Okay? That's what you're allowed to refer to unless I introduced your statement. Then you can refer to it, which is what I did later on. You don't get to read the same bullshit that you spent God knows how long thinking up and writing on a piece of paper as your sworn statement. Okay? You don't get to think of bullshit to make up and then copy and read it back out. You have to go by your own memory. But David showed that he was a bit slow on the old memory. The request from the statement. Under questioning, his evidence was that he started his shift at 6 a.m. on the 15th of April. He was deployed to State Highway 16 to use radar to detect vehicles travelling in excess of the speed limit and to police other road safety matters. Pre-deployment checks were carried out on both the police vehicle speedo. Now really, how did you check your vehicle speedo? Did you have an odometer checker nearby, did you? So there were no preliminary checks done on the vehicle speedo and the installed radar. And the logbook was completed. Senior Constable Lee explained in detail the purpose and the use of the logbook and the checks undertaken, including the fork test. Yeah, I got forks too. They wouldn't let me test David's hearing. I wonder why. Perhaps he's fucking deaf. Senior Constable Lee drove down Kumu via Waimaku. His radar was set to measure the speed of the vehicles travelling towards him. The weather was clear and visibility was good. At approximately 8:30 a.m, at a point just prior to Waimaku Township, still in the 80k area, as David testified, Waimaku Township, where signage shows the speed limit decreases from 80 to 60 kilometres per hour, well, it used to be 70. He saw a lone car. Sounds ominous. That would be my lone car. Lone car approaching from the opposite side of the road towards Kumu at a speed he estimated to be 80 to 85. That was in the split second that he saw me before clicking me. Not in the 100 metres tracking history that he viewed. No, because there wasn't 100 metres that he saw me until he fucking stuck his lights on. So, guess you didn't follow your own tracking history rules in the manual, did you? This was before the signage showed the speed limit increase from 60 to 80k for cars leaving Waimaku. No, it wasn't. There was no evidence of that at all, other than him saying, I saw it. There was no evidence provided to satisfy that he clicked me in a 60k area at all. There was only one vehicle in sight, and the audio response from the radar was increasing in sound, which indicated the target was exceeding the speed limit. Increasing in sound, so you're saying the volume or the pitch? Because you said the volume increase, and that's not what happens either, David. For someone that operates a road user, a stalker dual DSR radar detector, or speed detector, David, I would thought that you know that the tone increases, not the volume. Perhaps, you know, you were suffering from a bad sexual experience the night beforehand and your hearing wasn't as good. I'm not sure. Senior Constable Lee looked at his radar reading of 85 kilometres an hour, which confirmed his own audio and visual observations, because he's fucking the $6 million man. The radar was locked onto the oncoming vehicle and the reading showed 85 kmph, with the police car travelling at 61 kilometres an hour, so he was speeding too. According to him, if he was in a 60k area and he's doing 61, David was speeding. So if you're committing an illegal act, are you allowed to enforce laws? I don't think so. The senior constable observed the vehicle to be a Mitsubishi station wagon with the registration number being FAN. And then he said some fucked up numbers. So, see, they can't even write this fact right. After the vehicle had passed, the senior constable activated his vehicle's flashing lights. Really? After the vehicle had passed, he put on his flashing lights. So how on earth did I see him approaching me with his lights on then? How did that happen? How did I know to pull over? It wasn't because I saw him in the rear vision mirror. It's because he put his lights on before he even passed me in the 80k area. Turned and followed. The Mitsubishi stopped, and so did Senior Constable Lee, 1 to 2 metres behind. Before exiting the vehicle, the Senior Constable took photos of both the radar display and the Mitsubishi registration plate FAN 394. These were provided to the court. He got out of his car and approached the Mitsubishi to speak to the sole occupant, who was the driver. Mr. King provided his details, and by using his mobile phone, Senior Constable Lee was able to visually confirm through the New Zealand Transport Association system, which means they can pull up anybody's face they want to for identification, system that that the person he was speaking to was Mr. King. His full name and address. So they're saying that they could tell by the NZTA system that the person he was speaking to was Mr. Keane and his full name and address. The senior constable advised Mr. Keane he would be receiving an infringement notice and that he was now free to go. Was that before or after you harassed me about, oh, you should have tried that another weekend because it was Easter? Or was it when I said to you, what are you doing? I'm in an 80k area. You like to, you know, just say there's no possibility that I said that, and that I said, what are you doing? I was almost in an 80k area. Why would I say that? Come on, people, you know me. I've been YouTubing for 10 fucking years. Would I ever say something that would put me in guilt? No. Moving on. The senior constable advised Mr. Keane he would be receiving an infringement notice and he was now free to go. Senior Constable Lee stated Mr. Keane had said to him, I was about to enter the 80 kmph zone. No, I didn't. You just lied on the stand, David. There's no fucking way on this God Green's earth that I would be saying anything like, what are you doing? I was just about in an 80k area. No. I told you I was going to get Easter eggs. You completely forgot that. Got to wonder if your memory is really as good as it says. Senior Constable Lee drove back to the approximate position he was when he determined Mr. Keane was speeding and took further photos. These were provided to the court. Yeah, that was within 250 metres of the change of speed area, wasn't it, David? When you shouldn't have been operating your speed detector. Yes, that's what your manual says. Senior Constable Lee drove back. Yep, right. 12. The following documents which had been disclosed to Mr. King prior were entered into evidence. Exhibit 1 was the infringement notice. Exhibit 2, photos. A, showing the start of the 60k MPA zone. B, photo taken showing the radar mounted in the police car, showing with speed of 85 and 61. C, photo of rear license plate of the Mitsubishi vehicle. FAN 394. Exhibit 3 was the Stalker Radar Certificate of Accuracy. Exhibit 4 was the Certificate of Accuracy for the speedometer in his little pig vehicle. Exhibit 5 was the radar logbook for his Holden pig vehicle, completed on the 15th of April. Exhibit 6 was the Certificate of Proficiency for the idiot behind the driver's wheel in the pig vehicle. Enforcement equipment number issued to David John Lee. Thank you. Now we know your middle name, Johnny. David John Lee. 4th of June 2021. Senior Constable Lee stated he had been policing for about 15 years, but in road policing since 2020. So he's only been doing it for 3 years, but he's been a pig for fucking 15. So what does that say? He's done something wrong and he's been sent to the road policing unit because he can't do the rest of his job properly. Cross-examination. 13. When asked by the prosecutor what he would do if he wasn't sure if he couldn't correctly identify the vehicle, the senior constable said he would not issue the ticket, but on that day the defendant's vehicle was the only other car on the road. So what? Cross-examination. Mr. Keane asked the senior constable why he had not taken a photo of the driver of the Mitsubishi station wagon. The senior constable Lee replied that that was because Mr. Keane had identified himself. No, I fucking didn't. Senior Constable Lee was asked if it was true that he had said the name and address to the driver, merely asked for confirmation. Senior Constable Lee's response was no. Another lie. I don't think I would have. Oh, so he's admitting that he doesn't think either. That's probably accurate. The senior constable agreed he had stopped the defendant in the 80k zone and agreed there were no dates or times on the photos, but stated under oath that his evidence was that they were taken at the time stop. Okay. And of course, the fact that it was under oath means we should give it more weight. Are you telling me that no police officer in the history of the world has ever lied on the stand? So why mention under oath? We know he's a witness, he should be under oath, so why state that, other than to try and give him more credibility? Could that be it, justices? Justice of the peace? 15. When the senior constable was questioned about his position on the road when he locked the radar, he agreed he was in the 80k zone, about to enter the 60k zone, and that Exhibit 2A was taken from the 80k zone area. He was clear Mr. King's car was inside the 60k speed limit, so he was clear. It was only his testimony. There's no evidence other than him saying so that I was in the 60k area. All evidence he provided showed me in the 80k area. But that's fine. Apparently testimony alone is good enough to satisfy beyond a reasonable doubt in these day and age. 16. Mr. Keane asked Senior Constable Lee if he had noticed the stalker surveillance device on the dashboard in Mr. King's vehicle, and he replied that he had not, because David is so observant, isn't he? He knows what he's looking for. Mr. Keane asked Senior Constable Lee when the radar was reset, and he stated after the stop was completed. He agreed it was possible to not reset the radar. The court permitted Mr. King to show a picture of his own locked radar display of 79 and 66. See, they can't even fucking tell the facts correctly. The photo showed 79k and 56, not 66, you stupid old daft twits up on the fucking stand. Get your shit right. And produced photos taken later on his car parked behind other vehicles with that fixed display, showing that if the cops don't reset their display or unlock it, they can lock it onto a speed that's above the limit and pull up behind as many vehicles as they like and issue tickets. That's what that shows, that it is possible for them to be completely and utterly dishonest. So say it ain't so. 17. Mr. Keane referenced the New Zealand Police's Speed Detection Equipment Owner's Manual. No, it isn't. It's not. Operator's Manual, not Owner's Manual. Again, Justice of the Peace can't get simple titles correct. Where were we? The manual. Although this evidence had not been disclosed previously by Mr. Keane to the prosecution, why? Because they already fucking have it, and they're the other cunts that gave that copy to me. So they should be aware of it already. The court ruled the manual could be entered into evidence. Great, because I'll be using that in the appeal. Mr. Keane referred to page 13 of the manual, and in particular to the operational requirements, which stated an ideal site is straight for at least 100 metres, and that the operator must ensure they consider a site not within 250 metres of a reduction in speed limit. Senior Constable Lee responded that the reference to 250 metres did not apply in this case, as the manual reference was about the target vehicle. You liar. The manual's reference was about where the operator should be operating their detection device. It has absolutely nothing to do with the target vehicle, so why don't you mislead the court some more, David? And it did not imply the defendant was in the 60k zone and clearly seen coming towards him doing 85. And what evidence did you supply other than you saying so, David? What was that? Oh, none. Oh, okay. The defendant was in a 60k zone and clearly seen going. Mr. Keane asked Senior Constable Lee if it was possible Mr. Keane had said after the stop, "What are you doing? I'm in the 80k zone." Senior Constable Lee responded, "No." So it's absolutely not possible that I didn't say what I said. Is that it? It's not possible. You couldn't have possibly misheard me. Is that what we're led to believe? Such a keen, sharp intellect. You're a piece of shit, David. And I'm going to be coming back to do some more recording around the police stations now. You've reinvigorated my want to actually do some more auditing of you cunts. And guess what? I'm coming for yous all. 18. Senior Constable Lee gave evidence under further questioning from the prosecutor, stating that the manual on page 13 referred to 250 metres as an ideal distance, not mandatory. No, it doesn't. That's a lie as well. And in fact, let's just have a look. Page 13. Let's have a look. It says right there, okay, you must ensure you consider the following. Tick, not within 250 metres of a reduction in speed limit. And let's just turn over the page. Radar moving mode. The basics of stationary radar apply to the radar used in moving mode. Is that right? So there you go. Page 14, first line, David, says that you are lying to the court because you're saying that the stationary mode doesn't apply in moving mode. And I just showed you cunts in the manual that it fucking does. So I guess you're not that familiar with the manual. Or at least I'm more familiar with it than you are, David. For radar detection, but that it is when the police car is stationary, not moving. In this case, the senior constable's vehicle was moving, so this did not apply. Lie. Defence evidence. Mr. King stated he did not wish to testify. Why on earth would I? Or to call any witnesses, or to make a statement, as he felt the questions he had asked were sufficient. Here, I proved beyond a reasonable doubt that there is doubt whether or not I was in the 80 or the 60k area, and the police did not satisfy beyond a reasonable doubt that I was in the 60k area when he detected me. Other than his fucking own words that come out of his mouth, there was no evidence. The court accepted that without prejudice. Oh, how lovely. You didn't say, we'll accept that without prejudice, though, did you? No, that's just something you're throwing in the bit of paper to make it look good. Submissions. 20A. The prosecution's submissions was that this matter was a very straightforward charge under the Land Transport Act, Section 40 and Road User Rules 5.1, of exceeding the speed limit in a 60k zone. The car was lasered by a qualified user and of a certified device. B. Mr. Keen's submissions was that the police had failed to prove beyond a reasonable doubt that his vehicle had been in a 60k zone and travelling 80k. That's exactly right. The court's decision. With regards to Mr. Keen's submissions to the court prior to the commencement of the judge-alone trial, the court is satisfied that the disclosures sought and provided by the prosecution and relevant to the charge were completed. Is that right? Well, I disagree. Mr. Keen's decision to continue with the trial and to cross-examine and present evidence without representation was non-prejudicial. The court proceeded on the core principles of assumption that the assumption of innocence. Assumption of innocence? No. Go and read Bill of Rights Act, lady. It's not an assumption, it's a presumption of evidence. Nobody assumed fuck all. Well, you guys did, and that just made an ass out of you and all of us. Assumption of innocence until found guilty, and for the charge to be found proven required the essential elements of the relevant legislation to be proven beyond a reasonable doubt. The essential elements of the charge of time, date and place, and that Mr. Keen was the driver, appeared not to be in dispute. Mr. Keen did not dispute Senior Constable Lee's evidence in that he was driving the vehicle. Well, why would I dispute that? Because you never proved it, David. Registered to him on the NZTA website, it's also registered to another person as well. But then you guys just pick which one, don't you? On the 15th of April on State Highway 1. Really? See? State Highway 16. Can't get your facts right. Nor did he dispute that he was stopped by Senior Constable Lee in the 80k zone before Kumu. No, I didn't dispute that. You know why? Because I didn't give evidence, you cunts. And you can't go by the fact that I didn't dispute it because I didn't give evidence to give him more weight. No. I'm not going to dispute something that they haven't proven beyond a reasonable doubt. Am I? A, whether he was in a 60k zone when the radar was locked, and B, what Mr. Keen disputed in his cross-examination of Senior Constable was A, whether he was in a 60k zone when the radar was locked, B, whether the radar was activated in accordance with page 13 of the manual, and C, whether the radar had been cleared from a previous stop. Well, no evidence was provided to prove any of that. 23. While the court agrees that Mr. Keen was stopped in an 80k zone, so even the court agrees that I was stopped in an 80k zone, evidence is accepted that shows the offence took place inside the 60k zone. What evidence? And that the speed recorded was 85. The notes taken on the day, the photographic proof of the verbal recollection of Senior Constable Lee under oath are consistent with the radar proof. The evidence of Senior Constable was that he clearly identified Mr. King's vehicle prior to the end of the 60k zone speed zone leaving Waimaku when the visibility was clear and that there was only one car on the road at the time of the radar activation is accepted. The recorded speed of 85k was on the equipment that had been tested and certified as accurate and required. 24. The court has considered the evidence of page 13 of the manual presented by Mr. Keen on how the radar should be operated. The court is satisfied that page 13 of the manual is referring to the use of radar in stationary mode, so the court didn't turn the page either. There is no dispute that the police vehicle was moving at the time of the detection for this offence. The photos that Mr. Keen produced after the event using his own installed stalker showed that the installed radar can remain active if not reset. However, the photos do not relate to the equipment installed in the police Holden vehicle on the day. In addition, the operator of the equipment on that day was an experienced police officer. Whoop-de-fucking-do. Experienced police officer does not come into it when you are giving me and him the same weight. Does it? Certified as proficient in the operation of the radar equipment, we accept that he was clear it was not still locked from a previous traffic stop. You accept that without any evidence. Why, honestly, I'm amazed that Jay Jonson didn't just get on her fucking knees and start swallowing David whole. I mean, Jesus. They should have started fucking, oh, we're not worthy. 26. The court is satisfied that the infringement notice was issued in accordance with legislation. Well, there's no doubt about that one, was there? And this matter is proven beyond a reasonable doubt. Well, there is doubt about that. So you tell me, guys, is testimony alone enough to prove beyond a reasonable doubt that something happened without any other supporting evidence, given all evidence showed I was in an 80k area, other than David's fucking fork tongue wagging on the stand? Is there anything else? The answer is no. But they consider that enough to prove beyond a reasonable doubt. I'm coming for you, cunts. I will see you in appeal. 27. The court orders the defendant, Mr. King. You can go stuff your order right up your fucking asses, J. Jonson and T. Holden. I hope that your ass is fully lubed to take your order and shove it so far up you can taste it for the following week during breakfast time. Mr. King to pay $170 plus $30 court costs. $30 court costs, and yet all the other court costs I've been listening to lately have been $130. I wonder why. So, yeah, I'm going to be appealing it. And even if I don't win the appeal, I'm going to pay them off at, say, $5 a week. Because I won't notice that. If they do find me guilty on appeal, I will accept it. Okay? Because at the moment, evidence has not been provided to satisfy beyond a reasonable doubt that I was in a 60k area when he locked my speed. Other than his lying forked tongue, and no doubt David and, you know, Sergeant Mackenzie and all the rest of those paid professionals that were all getting paid in that courtroom, the only one that wasn't getting paid, were just there making money. None of them traded fairly. The judges, the justice of the peace misrepresented my submissions. They misinterpreted what I had written down, and they put more weight onto his testimony than me ripping them apart and proving that it was beyond a reasonable doubt that he was in the 80k area when he clicked me, and that he should not have been operating it within 250 metres of a reduce of speed sign. It's not about me approaching an increase of speed sign, it's about the operator and where he should be using his device legally. And his manual says he shouldn't be. He misled the court, stating that it doesn't apply, even though I've showed you on the next page over the basics of stationary mode apply in moving mode. That seemed pretty basic to me, but this is a police officer. Basic things might be hard for him to grasp. Anyway, guys, I will keep you informed. I'm going to be releasing everything. I will show you all of this as well, and I'll see them in appeal. And if I don't win appeal, I might not accept it. I might then go for a judicial review. We'll see. But I'm not going to go for a judicial review because that won't be granted until I've done the appeal, because they'll turn around and say, oh, we can't review this because you haven't exhausted all the other avenues, i.e. you haven't appealed it first. Because that's the shit they pull. Much love to you guys. I will see you on the flip side. Hope you're all doing well. I seem to appear to have cooled down a little bit. I'm not as red. So, yeah, now I'm going to go and cook dinner for my family. Why? Because it's my 18th wedding anniversary today, guys. 18 years. I know most guys would say, yeah, of hell, no. It's not been a bad 18 years. And how many people can say they've been married for 18 years in this day and age? You know, still got all the kids around you, still got a happy wife. You know, how many people can say that? Not many. Less than 50% of people that get married can say that. So I guess I'm in the minority. Much loves to you all. If you've watched this through to the end, thank you so much for listening to my babble and my going on. I do get emotional, but fuck it. You guys might as well have a look. and I'm going to spend the next 6 hours probably editing all this up and showing you all of the law that goes with it. Much love. See you guys. And yeah, at the moment, I've got matters in the Motor Vehicle Dealers Tribunal, the High Court for Appeal, and the Supreme Court for my friend down in Rotorua, who we've gone all the way to the Supreme Court now over a Section 10 Bill of Rights issue that the High Court never traded fairly on. The High Court denied jurisdiction and then made a judicial decision, even though they refused to hear the matter because they said a High Court, the only court in New Zealand that has inherent jurisdiction, more power than any other court, but they declined jurisdiction and then made a decision to award costs, even though they've just said they don't have jurisdiction. Go figure that one out. So yeah, Supreme Court for that one. And I applied for leave in the Supreme Court and it got accepted. Yes, I know the little tricks to get that happen. And now we've just done the submission, so we're just waiting for the respondent's response. We'll see what happens. Much love to you guys. Keep cool till after school. Bye now.